Vice Chair Greenman's making her way up to the front, and she moves that House File 2567 be, I believe, placed on the General Register. I believe that's the motion. Or Vice Chair, what is your Judiciary? Okay. Be recommended for re-referral to the Judiciary and Civil Law, Finance, and Policy Committee. So again, members, we're taking the second bill first. And so, Vice Chair Greenman, please present your bill.
Thank you, Mr. Chair. We actually have an amendment.
Okay.
There's two amendments. They're sort of drafted as an amendment to the amendment. They are both involved, and I will let you know I have an amendment. I'm happy to explain them.
Yeah, sure. So it's the A1, which is the underlying amendment, and then you're saying that, yeah, the A2 is going to amend that. So first you want to move the A1, correct?
Yes, Mr. Chair.
Okay, and then we will have you move the A2 as well then? Okay, and then, yeah, if you can just describe those two amendments together.
Thank you, Mr. Chair. These are amendments that were, some of them were adopted in the Senate, reflecting common sense exceptions to this bill that have been worked out both with stakeholders and also in other states that have been pursuing this. So allowing an exception for credentialed training programs that where someone gets a credential and a mechanism that makes sure that they're fair to the employees. An exemption that would be the amendment to the amendment is an exception that would allow for moving fees and a regime that makes sure that when they are given and agreed to, the repayment structure is fair. It also eliminates DLI's enforcement authority, which eliminates the fiscal note. It brings it in line with the other restrictive covenants, employment covenants, non-competes, no poaches, and shadow non-competes, which we have dealt with, and makes it so that they have the same enforcement regime and also that there's no cost.
Okay, thank you, Vice Chair Greenman, and these are also amendments that you wish to get the bill in your form, so in the shape you wish. So, Representative Schultz, you got a question about the amendment?
Mr. Chair, just primarily around process here.
Yes.
Just making sure that we're adopting one amendment at a time and not trying to adopt two at a time.
Well, right. The thing is, though, we would be adopting the A1 as amended. So we had to have the A1 before us in order to adopt the A2. So we have the A2 before us. We're going to adopt that, or I guess we'll make a decision about it, and then the A1. So I think so far we've been fine, but thank you. And I'm done being sarcastic towards you, Representative Schultz. Or if I am sarcastic, I'll be very obvious about it. It's also his birthday today, I gather. Oh, then I'm definitely not going to be sarcastic toward you on your birthday, Representative Schultz. So done for multiple reasons. Well, happy birthday to you. Okay, members, any questions about the A2 amendment? That's the one we're going to take first. Then all in favor of approval of the A2 amendment, please say aye.
Aye.
Aye. Any opposed? Aye. Okay. And then the A1 amendment as amended is now before us. Any questions about that one? All in favor of approval of the A1 amendment as amended, please say aye.
Aye.
Any opposed? Aye. Okay. Then the two, Representative Greenman, House File 2567 as amended is before us. Please present it.
Thank you, Mr. Chair. House File 2567, right? Okay.
Correct.
Is a bill that prohibits the stay or pay provisions that trap workers into jobs they don't want to be in or they want to leave, and forces them either to stay or pay money to their employer as the price of leaving. So what is a stay or pay provision? Imagine you're a pet groomer, you're making minimum wage at PetSmart, and when you want to leave, you tell them you want to leave, they tell you that you owe thousands of dollars for quote-unquote on-the-job training, despite having no training schedules, no consistent training available, and a groomer who was, during that period, doing work for paying customers. Or you're a truck driver who is sexually assaulted while starting your new job and told by your supervisor without a video they couldn't do anything. And then when you say, I need to quit my job, the company sends you a bill for $9,000 because of that training repayment assistance program or provision. Or you're a hairstylist who already has a cosmetology license, and when you want to leave for a better job, you left for a better job after a year was up, you're told you owe $20,000 in back training fees, despite the fact that you went to cosmetology school and paid your own tuition before you got there. So you're a nurse and you switched jobs between hospitals for better working conditions. 3 years later, you get a letter in the mail saying you still owe the previous hospital $5,000 plus attorney's fees, and it's unclear what training you ever received. You were a nurse before you went to that program, that school. And in nursing, and I think it's indicative to look at nursing like we look at the rest of our economy, these kinds of programs, these traps, as they're called, are increasingly common. Up to 45% of new nurses are bound by these agreements. It's an increasing practice, which also is more common in places where hospital markets are more consolidated. They have a higher level of consolidation, and they have more control over their labor market. Numerous reports suggest that hospitals with higher rates of unsafe working conditions and higher rates of unsafe patients use these agreements, often with payback amounts being between $5,000 and $50,000. The most common type of stay or pay contracts, as I said, are traps, training repayment agreement provisions. They are provisions that force folks into the condition of employment, so when you're signing your contract, and they use threats of debt collection or litigation to lock workers in place and limit their mobility and their bargaining power. And the training in question can oftentimes range from potentially preparation for a recognized credential to very basic company-specific training that is really just about training you on how to do your work that the company wants you to do. So think about the PetSmart or sandwich artist kind of training. And workers and it costs the workers, they have to repay oftentimes completely at the discretion of their employers. High interest rates, attorney's fees, and in some cases, the ability of employers to withhold final paychecks and retirement balances. Now, these kinds of provisions are not new, but they are increasingly growing, especially in low-wage work where folks don't have bargaining power. They are essentially creating a new wave of indentured servitude. These are especially in jobs that are disproportionately held by low-income folks, women, people of color, and as we discussed, nurses, EMTs, retail workers, construction workers, all of these industries we've seen these traps into. It's estimated that now 10% of all U.S. workers are bound by traps, and that's millions of workers in jobs across the country. And like their restrictive covenant cousins, non-competes, shadow non-competes, and no-poach agreements that we have spent a lot of time in this legislature and this committee talking about, these agreements reduce worker mobility and bargaining power and take away people's freedom in the labor market. So if you believe in a free labor market, you believe that one of the things that makes that provides a robust workforce is the ability to go to a different job, the ability to compete, and in some cases where there's high demand, compete for better wages and better working conditions, then traps are a real barrier to that. So these restrict workers, they restrict workers seeking better wages, working conditions, and they limit career trajectory growth, just like when we talked about non-competes. So recently, the FTC estimated that these clauses collectively deprive workers between $250 billion and $296 billion a year. The federal government, the FTC, was actually working on these like non-competes and everything else. They've been challenged by the same folks who probably submitted letters, which are the employers, the increasingly consolidated labor market who want the power to lock their workers in place so they don't have to pay better wages and they don't have to worry about competing with their competitors. So these are bad for workers, they're bad for competition, they're bad for our markets. Let's end this practice, and I have some testifiers.
Thank you, Representative Greenman. So there's 5 individuals testify. If Hannah Ford and Lindsay Lee can make your way to the front. I'm going to ask folks to keep your remarks limited to 2 minutes. I'll try not to cut you off, but if you really can limit yourself to that, we have quite a few people to testify. So do we have our first testifiers making their way up? Hannah Ford and Lindsay Lee? Okay, yeah. And our third testifier is going to be on Zoom, I gather, and so we'll be ready for that. Okay. So yeah, if Hannah Ford, if you can, once you get settled in, if you can identify yourself. Yeah. And again, asking folks to keep yourself just 2 minutes. Thank you.
Hi.
Hello.
Hi. My
Hello.
name is Hannah Ford.
Oh yeah, you just want to lean right in the microphone.
Hi.
Hello.
I'm Hannah Ford. I'm a certified lash technician. I do eyelash extensions. Eyelash extensions are pretty similar to hair extensions in that it's just extensions for your eyes. I am certified by the state. I went to school for this. I paid up to $2,000 for a rigorous program to be certified in the state of Minnesota. After I got my state license, I was looking for work. I came across a studio called Deca Lash. At Deca Lash, I started pretty quickly. The onboarding process was very quickly. I was told that I'm signing an agreement to pay for tuition. We didn't really talk about it that much. We didn't really go into detail. I was just told to sign off in order to start working. Once I started, the quote-unquote training started. Training consisted of taking pictures of the work that I had done and sending it to an email chain to their trainer in New Jersey, I believe she was based out of. So there was no one-on-one hands-on training, no learning, no advancement. Their training did not include any additional certificates or I couldn't do anything with their training, no more than what I already had from the state. When I decided to part ways with them because I wasn't earning much money and like I said, there was no advancement. It just didn't make sense for me to stay. Once I decided to leave, they reached out to me later thereafter stating that I had owed them $3,000 for a training that I did not receive. I wasn't told when I had to pay it back. I was just told that I owed them. That was very overwhelming. $3,000 is a lot of money to pay at one time for something that I didn't get. I felt extremely trapped. I didn't really know what to do with that information or where to turn to. That's why it's super important for bills like the pay to stay to be passed to protect employees like me that were pretty blindsided by that.
Thank you so much for sharing your experience. And I'm sorry you experienced that, but thanks for sharing it today. Appreciate it. Yeah. And Lindsay Lee, you're up now.
I think I said the CA. Ms. Lee is here from the AG's office to answer questions if
Okay.
needed, but not to testify.
Okay, great. All right, good. Glad to have you. In that case, we'll move to our testifier via Zoom, Chris Hicks. And so if you can please identify yourself once you're up. I'm hoping you can hear us.
Yeah, can you hear me?
Yes, we can hear you. Yep. And so you've heard the request to keep it to 2 minutes, and please proceed. And do identify yourself at the beginning.
Thank you for the chance to testify today, Mr. Chair. My name is Chris Hicks. I'm a senior policy advisor at Protect Borrowers, a nonprofit policy organization focused on household and consumer debt. I'm based in Kansas City, Missouri. We're proud to support House File 2567. Increasingly, our investigations, reporting, and litigation have found that employers are requiring workers to pay a fee if they have the audacity to quit their jobs. The most common example are training repayment agreement provisions, better known as TRAPs, which you just heard about. TRAPs put workers on the hook for thousands of dollars in debt to repay employers for their so-called training costs if they leave their job before a fixed period of time. TRAPs let these businesses use the threat of debt collection or litigation to lock workers in place, limiting their mobility and bargaining power and leveraging crushing financial penalties if a worker does dare to leave. TRAPs gained national attention 3 years ago when a former PetSmart worker sued the company, alleging that PetSmart was trapping workers, often earning minimum wage, in stressful and grueling positions or requiring them to pay $5,000 if they quit. These terms not only block employees from pursuing higher paying jobs, but can prevent workers from leaving to pursue higher education, starting a new business, or even taking care of a loved one. For the vast majority of workers, the threat of debt becomes a form of modern-day indentured servitude, trapping them in jobs with low wages and bad working conditions. In other types of stay-or-pay contracts, employers have demanded that departing employees pay them the cost of their replacement salary, liquidated damages, costs related to immigration, or even lost profits. Immigration and visa fees used by third-party healthcare staffing agencies and hospitals have come under great scrutiny in particular. Consider the story of Jane Engen. She started working as a nurse at a skilled nursing facility, and when she did so, she was assigned 20 to 25 patients at a time and spent each shift praying that she wouldn't make mistakes. After 5 months, Ms. Engen decided that the toll of chronic understaffing was taking on her mental health was too great, so she gave her notice. A week after her final shift, the company sued her for $100,000, claiming breach of contract, fraud, and expenses related to immigration visa and other costs. These nurses are forced to work under conditions that no American wants to work in and threatened with massive penalties if they try to quit. These contracts create dangerous conditions for Minnesota healthcare patients and line the pockets of companies undercutting American workers. We also see stay or pay contracts used in aviation, technology, transportation, among other industries. This bill would protect workers' ability to leave a job without penalty, benefiting workers and honest businesses across Minnesota. I applaud the sponsors and legislator for taking up this issue. Thank you for the chance to testify, and I'd be happy to answer any questions.
And thanks for your testimony. I appreciate it. If we can have the final two testifiers make your way up, we'll need to have some space made for them up there. You just wait in the front if you can. So Lauren Schotthorst and Dalton Danielson. And so I think, Ms. Schotthorst, you're going to be going first, and so please identify yourself once you are ready, and then proceed with your testimony. And again, asking you both to keep it just 2 minutes. Thank you.
Good morning, Mr. Chair and members of the committee. My name is Lauren Schotthorst, and I'm the Director of Workplace Management and Workforce Development Policy for the Minnesota Chamber of Commerce, a statewide business organization representing 6,300 businesses and more than 500,000 employees across the state. A majority of our members are small to mid-sized businesses. The Chamber appreciates the opportunity to testify in opposition to House File 2567, legislation seeking to prohibit employees and employers from entering into written agreements or contracts that stipulate an employee pay back an employer a certain sum of money if the employee leaves the employment before the passage of a stated amount of time for certain costs or reimbursements. These types of employee retention mechanisms are fairly common and vary, as you've heard. They include anything from relocation agreements and sign-on bonuses to retention bonuses and tuition reimbursement programs. Beyond that, you'll find employer-supported professional certifications, immigration assistance, and employee loans as opportunities that employers have made available to their employees in exchange for a reasonable term of service. There is nothing unconscionable about this, nor should it be against public policy. It is reasonable to expect a return on this type of discretionary employer investment in employee development, support, and training portfolios. Despite some examples shared today, these agreements, when done properly, can be generally mutually beneficial. A blanket prohibition on these types of agreements, where this bill started, negatively impacts employees, as employers simply won't make these agreements available anymore. We appreciate that the amendment seems to contemplate some exceptions and thank the author for offering it, but it doesn't go nearly far enough or address our issues with the bill to change our position at this time. Industries across Minnesota's diverse economy are experiencing several troubling trends, including high costs and steep increases in regulation and business mandates on workplaces that are already heavily regulated in Minnesota. Minnesota's employers and employees are counting on lawmakers to work towards an agenda for economic growth and making Minnesota's economy stronger, more vibrant, and more viable. Instead of reducing costs or making it easier for Minnesota businesses to remain competitive, this bill takes the opposite approach. Because it will impede Minnesota's business competitiveness, we respectfully encourage a no vote on this bill today. Thank you, Mr. Chair.
Thank you for your testimony. Thanks for being here. And then finally, Mr. Danielson.
Yeah. Good morning, committee. Chair Pinto. Thank you for the opportunity to testify. My name is Dalton Danielson, Fiscal Policy Director with the Minnesota Business Partnership. The Minnesota Business Partnership, also called MBP, is an association of CEOs and senior executives from Minnesota's most innovative and respected large companies. The partnership represents state, regional, and global leaders in healthcare, med tech, agriculture, financial services, manufacturing, and more. Right now, our members compete nationally and globally for talent. To attract workers, especially into high-skill, high-demand roles, employers often front the cost of training, certifications, onboarding, and even relocation. We do appreciate the A2 amendment from the author, but still have significant concerns about unintended consequences that this may have, particularly line 1.6 on the A2 and the definition of outset of employment. Oftentimes, as someone continues in their career, they may have mid-career opportunities that would open them up to some sort of repayment agreement, whether that be education, relocation from another branch, another area of service into Minnesota. So potentially addressing that moving forward. Overall, the result of this will not be more opportunity, it will be less. And so as we look at investing in our employees, keeping options on the table, and as the chamber mentioned, when these agreements are agree to clear terms. They are useful tools for our employers to attract and retain the best talent here in Minnesota. I will also, for the record, respectfully yet unequivocally disagree that the trap mentioned by testifiers is the standard in these agreements. Our companies take a great deal of care in respecting their employees and creating great workplaces for them. And so these agreements moving forward are important for our businesses. So thank you, Mr. Chair.
And thank you for your testimony. Thanks for being here. Is there anybody else, member of the public in the room who wishes to testify on the bill? And not seeing any, so we will close testimony and then moving to member discussion and questions. Members, Representative Schultz.
Thank you, Mr. Chair. Representative Greenman, good morning.
Good morning.
Thank you
Happy
for bringing
birthday.
a bill that is so fun to discuss this morning on my birthday. It's appreciated. And I just wanted to start by just asking a very broad and simple question. Why would we want the government to insert ourselves into this private contract?
Representative Greenman.
I think what you heard from the employer representatives is about power. They talked about useful tools for employers. They talked about discretionary for the employers. I think anybody here who talks to an employee who is working in a big company, especially a low-wage worker, does not hear about how they have their lawyers negotiating their contracts. These are contracts that are put in front of employees. Oftentimes, you get the minimum wage job or the middle-class job, you sign it or you don't. So when we talk about an unequal bargaining power, I think it's incumbent on us to ensure that we're protecting workers and we're protecting employees who don't have the corporate structure and increasingly consolidated corporate structure to demand any term they want and exploit workers and prevent them from leaving their jobs.
Representative Schultz.
Thank you, Mr. Chair. Representative Greenman, as a reminder to us, we have a relatively low unemployment rate, and we actually have more jobs available in Minnesota than there are employees seeking work right now, which is a good thing. And so I'm curious, just along the same line, how we really need to insert ourselves into this discussion when there are options for employees or people seeking work to go to another employer. As has been mentioned, fortunately to this point, we still do have many major businesses, Fortune 500 companies, headquarter economy businesses here in Minnesota, and that gives employees the chance to go find other work, potentially even in their field. I look at this and I'm curious as to why we would need to do this when there is choice in the marketplace today as to where people can work. But switching gears slightly, Mr. Chair and Representative Greenman, can you tell us what spaces, what industries, or whom was exempted from this bill through your amendments? If you could name them for us, please.
Representative Greenman.
Thank you, and I want to respond to the first point you made because I think you made my point for me. When we have a competitive labor market, what you want to see is people being able to go find another job, them being able to use the benefit of demand to get a better wage, get a better working conditions, and that is good. And these are exactly the reason we need to prevent them, is this prevents that movement on purpose, right? Because it is a way in a competitive labor environment for employers, especially as we look at consolidation, to keep people from leaving. It's expensive to lose employees, especially when we're talking about people at, your high churn, high turnover employers. You hear that all the time. Keeping workers is really expensive. This is actually a great way to do that. If you leave, you have to pay back $5,000, $10,000, $15,000. It means that actually leaving to go to somewhere else it's not the market deciding, it is an employer's, a provision in an employer's contract, much of which, as you've heard, doesn't offer any value. So I appreciate you making that point about why we need to do this. When we talk about and how we created these exceptions, what we were looking for is when you are doing something like an apprenticeship program or a certification program that leads to a credential that is of value to the worker, right? Not a credential that says you're training, PetSmart is training people on how they want you to do their job, or an eyelash technician is being trained on how Deca Lash wants to present their company. These are things, an apprenticeship program, a college degree, a certification that you don't go in having that you end up with. Those are all things that are of value to the worker. They're also of value to the employer. And that's why we crafted this, is to say that in those places, it has to be fair. There's a structure of you have to actually have a fair way to repay. A lot of these, if you look at these traps, a lot of what you'll see is that they're not actually based on anything other than what the employer says, $10,000, $5,000, they're a round number. When the exceptions we created are specifically around the places that workers and that the economy has said are of value and leave employees with value, not just discretionary tools and useful tools for employers.
Representative Schultz, back to you.
Thank you, Mr. Chair. I didn't hear any direct specifics, and if this is based around apprenticeship programs or similar related things, I would love to hear it, because I think that it would be fantastic for you to specify to us exactly who would be benefiting from the exception to this rule, and who would not, because my understanding is it might not be as blanket of an approach as you might suggest.
Well, I think it does say apprenticeship program in the amendment.
Believe I said
Representative
that
Greenman?
out loud.
Representative Greenman.
Yep, apprenticeship programs and related to the repayment of tuition for transferable credentials. As I said, these are credentials that actually have value to the employee in the workplace, not just value to the employer about how they want you to do the job or to keep you there and trapped.
Representative Schultz, anything
Just
further?
seeking specific examples for that, Mr. Chair. That's what I'm seeking.
Specific examples of apprenticeship programs?
Examples of, yes. Yeah, that's what I'm seeking, the examples of those who would be excluded from this law versus those who are not excluded.
Okay, Representative Greenman, I'll let you, before we move on to another
I feel like you're
question.
asking me for a counterfactual. I can read you the exclusion, the exceptions. And again, if you are in a registered apprenticeship program, if you are, if it is agreement related to the repayment of tuition for a transferable credit and credentials, and it meets the agreements, that the reasonable agreements, those are all, I mean, we're talking about economy-wide provisions, and that's part of why we, if you heard from the testifiers, it's in aviation, it's in construction, it's in the service industry. There's actually a great packet, a great report, and if you look in your packet, there's dozens of examples. There's a line, I didn't bring it with me, that looks at the average trap in some of these industries. And so I think that what I'm struggling with is, like, if you want me to, there's not an industry-specific exclusion. It is about the kinds of training that is provided to the benefit of the worker, and sometimes that's transferable credit, sometimes that is also apprenticeship programs, but it's a pretty broad set of things. What it is designed to do is say they are credentials that are worth it for the employee.
So we have 4 more questioners on the list, so we'll keep moving, and we've got a lot to do today. So I'll just ask folks if you can keep the questions as short as possible. Representative Greenman, if you're able to as well, but of course, there's a lot of meat here. Chair Baker, to you.
Thank you for this. I guess, Representative Greenman, I've used something like this before when I want to invest in somebody who I really have a lot of hope in my industry. There's contracts every day that happen in our business world, and these are basically, set up as kind of a trust foundation. If I want to invest in somebody's training or certification, again, I think it sounds like you say that that's kind of set aside. But are these agreements that you're talking about, are they legal documents? Are they, when you're saying they're being trapped, are the contracts written illegally where they've not been vetted to say, if you do leave early after this investment, you owe us X amount? Are you suggesting today from your testifiers that they were duped, were lied to in a contract? Did they not sign something that they understood? What about this contract that we all live and die with loans and things that we buy and our student loans? I mean, are those agreements legit?
Representative Greenman.
Thank you, Chair Baker. This actually allows me to make a really important point that we talked about when we talked about non-competes as well. There is a whole jurisprudence about unconscionable contracts, right? There are contracts where the bargaining power is unequal. There's lots of non-competes that were determined to be unenforceable. They were in people's contracts, and when the courts saw them, they were unenforceable. The problem with that, especially for folks, most folks don't have a lawyer, is that you actually don't know that they're unconscionable until you go to court. And so one of the things, there's probably a lot of these that are that may be legal. There are also many that are probably not. And it's all, there's a balancing test. What we're trying to do is say, give some power to the workers who are oftentimes signing contracts, right? 14 points, and again, if you can look at some of the contracts in your packet, 14, 15, 16-page documents, right, that are the take it or leave it. And most workers, I mean, I had to become a lawyer before I had a contract that I actually had some negotiation in. And so they are, again, as we heard, they are useful tools for employers. But if you have unequal bargaining power, which is in a lot of cases more and more what we're talking about, if you have unequal bargaining power, it is our job and it is incumbent on us to make sure that we are creating a structure that works for everybody. And right now, we don't have that in our economy.
Chair Baker.
Real quick.
Yeah.
And again, I'm going to keep it short too. One other thing comes to mind is, have you approached the sort of our military side of things, like the National Guard? They invest heavily into training, specialty things like electricians and engineering. They sign agreements that they can't leave early. So how does this work, your idea of protecting them when we invest heavily in them with, whether it's a certification or not, but it's intense training from our military? How does this affect, in your thoughts, have you talked with the National Guard about how this idea of yours would affect their ranks?
Representative Greenman.
Thank you, Mr. Chair. I'm not aware, and this will be helpful, this is going to judiciary, so we have some time, of contracts that require, and you may know better than me, require National Guardsmen to pay back their training. And if that's true, then we should have that conversation. This is not something that has come up, and I don't know if the Attorney General's folks are there in the conversations. And so I'm happy to have that conversation specifically as it relates to the U.S. government and the state government. It is not something that has been raised since, so.
Chair Baker, anything?
Just a quick follow-up. Yeah,
sure.
For me, this is a very hard bill to support today, even to move it on to somewhere else. This is, again, anti-growth this is going to hurt many more employees than help it. I think you're trying to get to something that is maybe a couple situations, and again, your testifiers, I'm sure, maybe we're wrong, but overall, this is not going to be helpful for private employers like myself or others to invest in promising young people, either their own internal training programs or agreements that we have. This I think, is going to do more damage than good. So thank you, Mr. Chair.
Thank you, Chair. Representative Zalesnikar. You'll pass, okay. And then I'll ask Representative Frazier and Johnson if you keep it very short if you can, but Chair Frazier.
Thank you, Mr. Chair. Ms. Ford?
Yeah.
First of all, your lashes. I just wanted to make sure I heard you correctly. I think when you testified, you stated that you paid $2,000 for your certification. Is that correct?
Through the state, yes.
Okay, through the state. Then when you got the job with your employer, you were given an agreement to pay $3,000, another $3,000. And what was that $3,000 for?
Ms. Ford.
For training.
And what was that training?
There was no training.
There was no
It
training.
was to take pictures and to send those pictures to an email chain to their trainer who is in New Jersey. So I never met her in person. She never saw my work in person. She didn't touch my lashes. It was just a picture.
So you didn't learn anything new from that?
No.
Ms. Ford.
And
Chair Frazier.
and then you were required to pay back that $3,000?
Yes.
Ms. Ford. Chair Frazier.
Thank you, Ms. Ford, for confirming what I thought I heard. I don't know how that's fair.
Me either.
And I think that's what this conversation is about. It is about fairness. It is about the unequal balance of power that employers have. Someone's looking for employment. You've got your certification. You've done the things you've been asked to do. You paid for those things. And now you're being asked to pay more than the certification itself. And you're not picking up a new skill. And you're being told, if you leave, you have to pay that back.
Correct.
This is about fairness. Thank you, Mr. Chair.
Thank you, Chair Frazier. Representative Johnson, very quick.
Thank you, Chair Pinto. A similar point, to try and help clarify Representative Schultz's question, the difference when he asks about leaving with something and what you're exempting, in Ms. Ford's case is a perfect example. She on her own went and got a state certificate, state licensure, then went to this employer and used that skill that she paid for and then left, and they tried to charge her for something else. Now, if this was different where she came in with zero experience and that business paid her to get the state licensure, then with your amendment, they in theory could come back and get that because it is a transferable benefit that she can take on to other places where she came in with nothing, got a certificate that is recognized not just by one company, but by the state. And then she could use that to build a business, she could use that to move on, but that's not the case here. So I just try and give a real world example of a testifier we have in how that amendment would change things.
Thank you, Representative Johnson. And Representative Bakeberg, very quick.
Very quick. Thank you, Mr. Chair. I'm looking at the A1 amendment, line 1.17, and then I'm also looking at the underlying bill for the definitions. So I see it, and I think this goes into Representative Johnson and Representative Frazier, the term transferable credit. I don't see a definition for transferable credit. So I think that's adding to confusion and frankly concern from my perspective. So can you define what transferable credit is?
Representative Greenman.
Thank you, Mr. Chair. And we took this from a set of other states who have been working on this. I think that it says transferable credential. And what that means, I think, is a credential or license. I think if you're interested, we could absolutely, I'm for definitions, add a definition, or if there's an opportunity to just cross-reference. The point is, and I think that this is what both Ms. Ford and Representative Frazier make, is getting something, a credential, a license, a degree that then allows you to take it somewhere else, that is a value to both the employer and employee. And that's why it's a transferable credential. And I think transferable is the key word.
Okay. Hopefully that covers it. Representative Bakeberg.
Quickly, thank you. I should have read it quicker or closer, but I think that's the definitions matter. Yesterday when I met with AFSCME, we talked about a number of topics, and that was one of the key things that we talked about, that definitions matter. So we need to have it right before we pass legislation. Thank you.
Thank you so much. And Representative Greenman, if you can keep it very short in your closing.
Thank you. And I think all I will say is this is about a level playing field. This is about ensuring that workers actually have the ability to take advantage of the competitive labor market that you mentioned, Representative Schultz, that they have the advantage to gain skills on the job that they can take other places. Instead, what these stay or pay provisions do is the exact opposite. They give more power to the employers, they prevent people from leaving, and they interrupt the freedom of the labor market. So with that, Mr. Chair, this is an easy one, like banning non-competes and like banning all the restrictive covenants. This is something we should do there's a lot more employees out there than there are employers. And this is actually, with the amendments, a really good compromise. It allows the employers to invest and incentivize while making sure that it's fair for the employees.
Representative Schultz, you have a process question?
Just asking for a roll call.
Roll call has been requested. There will be one. Motion, Representative Greenman renews her motion on House File 2567 as amended. Just verifying the bill number. Yep, as amended. Be recommended for your referral to the Judiciary, Finance, and Policy Committee. The clerk will take the roll.
Chair Pinto?
Aye.
Chair Pinto, aye. Chair Baker?
Baker, no.
Baker, no. Rep. Greenman?
Aye.
Rep. Greenman, aye. Rep. Mecklin?
No.
Rep. Mecklin, no. Rep. Bakeberg?
No.
Rep. Bakeberg, no. Rep. Berg? Aye. Rep. Berg, aye. Rep. Frazier?
Aye.
Rep. Frazier, aye. Rep. Hussein?
Aye.
Rep. Hussein, aye. Rep. Pete Johnson?
Aye.
Rep. Pete Johnson, aye. Rep. Wayne Johnson?
No.
Rep. Wayne Johnson, no. Rep. Kozłowski?
Aye.
Rep. Kozłowski, aye. Rep. Mueller? Mueller votes no. Rep. Mueller votes no. Rep. Schultz?
No.
Rep. Schultz, no. Rep. Zelensikar?
Zelensikar, no.
Rep. Zelensikar, no.
And there are, I believe, 7 ayes and 7 nays. Is that correct, Madam Clerk?
Yes, Chair.
Okay. And so with that, the motion does not prevail. Thank you all for the discussion. Thank you, Representative Greenman, for presenting the bill. Ms. Ford, thanks especially to you for sharing your testimony, your experience.